introduction of myself. Most of you know me, but maybe they're new people or whatever. But I always like talking about myself, so I can bend your ear for a moment there. And then we're going to talk about the class. And okay, and I give this class. I've given this class for several years in May. May is important for two reasons with the Supreme Court. Uh, One is that the way the Supreme Court's calendar works, the year schedule for the year, they start hearing cases, having arguments in the Supreme Court building in October, the first Monday in October. You may have heard that phrase. And they listen to arguments throughout the year. And then in May and June, June 30th is their self-imposed deadline for making all their decisions, issuing the decisions on all the cases that they've heard. And so there is a May and June, particularly June rush or busy season. Ginsburg used to say that's our busy season, June, when they actually have to write these decisions and issue them. And usually a goodly number of the toughest cases, the toughest issues are decided in June because the justices have spent the entire year or much of the year arguing amongst themselves and, in a convivial and civil way, of course, about exactly how that decision should come out. So the tough cases often come out in June. And so it's an interesting time in May to sort of say, okay, what are those tough cases? What are the interesting cases, the ones that will hit the headlines that are you can expect to see in the next 6 weeks? So that's part of what this class is about, to give you the major cases of 2021 that are still coming down the pike. The other reason for doing this in May is I'm a member of the, of the bar. I'm a member of the bar of the Supreme Court. I'm a retired federal administrative law judge. And May 1st is Law Day. The maybe only lawyers note it or remember it, but one of the responsibilities of lawyers, I think, and judges is to try to explain the judicial system to everyone else and to try to answer questions. And so I thought this is a good juncture to talk about the Supreme Court in recognition of May 1st, which is Law Day. I mean, it's also lots of other things, Labor Day and Internet, and May Day and whatever. But for that reason, I wanted to do this talk on the court. I'm from Washington, D.C., born and raised there. And so I've been a lawyer all my professional career and then a judge for the last 12 years. And then I retired. My grandfather came over from Greece when he was a little boy, and he worked drove a diamond cab in Washington, D.C. until he was 75 years old. My father was with the Navy, and in 1960, he was buried in Arlington National Cemetery. So all my family basically is from DC. And so if you live in DC, you can either grow up to be a tour guide or a lobbyist or a lawyer. And so I ended up being a lawyer, and that's how I got here. So with that, let's turn to a little tour of the court itself and some of the basics. I'm going to have two segments on this bit. One is going to be the basics of the court, its physical setup, its structure of how it works, and the second half will be cases that are coming down the pike, interesting developments that are occurring right now, and decisions which will be coming down soon. So the first part will be some review for those of you who attended this class last year, but I hope it'll be useful and interesting, and you'll be patient with us as we go through that. In fact, at the end or at any other time, if you give a review of this class, it would be valuable for me to know whether the repetition of some of this material was boring or problematic or not. I just enjoy any feedback you want to share about this class with the LLCC. Okay, so here's the Supreme Court building. I'm told that's a Corinthian style building. It was built in was finished in 1935. It only took them a year or two to build this thing. Uh, and they did it for less than $10 million. So it's pretty astounding. It was done during the Depression, obviously. And it's a beautiful building. And I hope if you get to DC, you'll have a chance to visit the Supreme Court. It's right across from the Capitol building, you know, the scenes where we saw the mob occupying the Capitol on 1/6. Well, if you just turned 180 degrees around, you'd be looking at the Supreme Court. It faces west, and they've got all sorts of statuary and ornamentation, and all the major lawgivers of the world are celebrated in stone and in carvings and this sort of thing at the court. My mom, when she was a little girl, lived not too far away up on Capitol Hill when they allowed poor people to live on Capitol Hill. Not anymore. And she used to come over to the courthouse and roller skate around on the white marble, which she said was great. And it was like 7 or 8, 10 years old, and the guards would chase her away, and she and her girlfriends just loved trying to roller skate at the Supreme Court. Here is another view of the court showing the steps going up to the entrance. The entrance doors are huge bronze doors. Each door weighs 6 tons and they're massive. And this is the steps to the court. There are 44 steps to go up the court, and people who argue, lawyers who argue cases at the Supreme Court, sometimes refer to the 44 steps. You know, it's sort of an august, when a lawyer argues in the Supreme Court, it might be one of the highlights of their career. So this is the 44 steps leading to the door of the Supreme Court. This door is now permanently shut, locked because of 9/11 security. You have to access it. I'll go back here by these side doors. If you can see my arrow moving around, there are side doors that you have to go in and that sort of thing. I might make another pause and ask anyone who has their video showing to please put themselves on no-show video, as well as silence. So if you have, you're seeing your picture on the board, if you can figure out how to do that, that would be great. Okay, so there's the steps, there's the doors. They're no longer accessible. It's more, but it's a very impressive building. Here's some constitutional 101 of where the Supreme Court fits in. The Constitution, written in 1789 or ratified in 1789, has 3 separate branches of government, as we all learned in Civics 101, and legislative body was Article 1, executives Article 2. So let me go back. 3 branches of government, and the judicial was the third branch, is the third branch, Article 3. And actually, the people who wrote the Constitution thought that the legislature, Congress, the House and the Senate, would be the major movers and shakers and the center of power and gravity for everything. The executive would be kind of secondary, and the judicial branch, which was a very short Article 3, it's quite short, was kind of like, well, okay, we're going to have a court. Not a whole lot was said about the details of the Supreme Court or the other parts of the judiciary. The next is the Supremacy Clause. The Constitution states flat out that the Constitution is the supreme law of the land, of the United States. If it's in the Constitution, it trumps anything in a state law, anything in a federal law, anything in a state constitution. If it violates the federal Constitution, it's kaput. It's not valid. It's invalid, as it were, unconstitutional. And so it's the supreme law of the land. And the Constitution actually isn't that long. I think So I think it's like 4,444 words. It's quite short. You can read it, pretty short. And it's got a lot of ambiguities or places where they left it open for later generations and courts to figure out how to apply it. But it's short. Now, there's a Constitution says that it's the supreme law of the land. And then, okay, but who decides what the Constitution, what the Constitution means? You get a certain phrase like equal protection or, whatever, cruel and unusual punishment. And who gets to make the decision of what is cruel and unusual punishment? Well, the Constitution doesn't say who's the final arbiter. And at the early stages, there's those that argued, well, they can just fight it out. The president may decide one thing, and Congress may decide something else, and the court can decide something else. But in 1803, this is the biggest single important case in the Supreme Court's history. The Supreme Court, and I call it Scotus, Supreme Court of the United States, they ruled that they're the final arbiter of the meaning of the Constitution. It's kind of like they just arrogated to themselves, well, we're the final word. That's what judges are supposed to do. They're supposed to say what the law is. That was the phrase they used. It is preeminently the function of the judiciary to say what the law is. And the Constitution is the top law. And so the Supreme Court is the final arbiter. And we've been living with that ever since. And that's fine. It seems to work pretty well most of the time. Next slide here is that the Supreme Court decisions are final. There's no appeal. No international court, no international criminal court, not the United Nations. Nobody can overturn a Supreme Court decision. You will hear people say, I'm going to, this violates the Human Rights Declaration as set forth in the United Nations Charter. Well, that's fine and good, but unless the Supreme Court says that it violates something, you aren't going to get an appeal to the UN or to the International Court of Justice. So it's a final arbiter. There's nobody else out there. So what happens if the Supreme Court gets it wrong or does something stupid? Well, how can you fix it? Is there any way to fix it? And one way is to amend the Constitution. If the Supreme Court says the Constitution says, as it did 30 years ago, homosexual sodomy, states are allowed to criminalize homosexual sodomy. Well, it doesn't violate the Equal Protection Clause. Well, somebody may not like that decision. Well, that's wrong. Well, you can amend the Constitution and provide to fix that problem. And amending the Constitution is extremely difficult. Another way is to amend the statute. If they're worrying about it, the interpretation of a law, like the Civil Rights Act of 1964 and voting rights, the proper interpretation of voting rights under the Civil Rights Act of 1964, well, that's a statute enacted by Congress. And if Congress doesn't like the interpretation that the court comes up with, Congress can amend the law. And that's a lot easier to do than amending the Constitution. Third way is get the Supreme Court to reverse itself. And it does that not infrequently. It changes its mind. It realizes it made a mistake. New people are on the court, on new justices. Or maybe there's the same people on the court and they realize they got it wrong. And the final way is civil war, which is, okay, we're out of here. We don't like that interpretation. I think we'll walk and thank you very much. Goodbye. And see if you can make that happen and make that stick. Okay, next. Here is the interior of the court. Now, no photography is allowed in the court at all. It is a very strict, strictly enforced. In fact, one time I went in with a legal pad. I wanted to take a pad in, and they took that away from me, and they made it. You put it in a locker. Get a and so they're very strict about that. But this is a photograph that the court took. It's publicity shot sort of thing. Not real good. It's got some reflection there, but okay. It's 44 feet tall, the ceiling of the court. And the 9 justices sit here in a slightly curved bench so they can sort of see each other a little bit. Roberts sits in the middle. He's the Chief Justice of the Supreme Court. He's not the most senior, but he's the Chief Justice. He's the administrative chief and head of the thing, but he just gets one vote on any decision, just like anybody else. If you're going to argue a case in the Supreme Court, you stand right there, real close, with your little podium there, and each lawyer will stand there in the hot seat, or the hot stand, I guess. The lawyers for the petitioner will sit here at that table. The lawyers for the defendant, I'll call it at the moment, sit over here. The press, Marcia Coyle and all the press, who are handle the Supreme Court, sit over here. The special guests of the court, of the justices, their family, maybe a guest that they've invited can sit over here. And the public, this is the public seating. And any member of the public can go in and watch court. This is, you see this fence, I guess you'd call it, that's maybe what you might call the bar. If you're admitted to the bar of the Supreme Court, you get to go inside this area. And this is where the lawyers sit. When I'm a member of the bar, I don't have to wait in line. I just go and I get to sit there and watch and listen to and watch an oral argument in the Supreme Court, if you're a member of the bar. Here is the configuration of the justices. As you're sitting here arguing your case, you generally want to know the names of all the justices. I mean, this is probably pretty basic 101. And here they are. And Roberts is in the middle, and then it goes by seniority. Thomas is the most senior judge. He's the oldest. He's been on the bench the longest time. He's been there like 30 years. But he's not the oldest person. His age is 73. So he's relatively young for the court, for having been on for 30 years. He's 73. The next one is Breyer. So right-hand side of the Chief Justice, left-hand side. Right-hand side, left-hand side. This gives you the seniority on the court. And this is Breyer. Breyer is generally a liberal justice. He's a blue justice, you might say. They don't like to be labeled that way, but that's the truth of the matter. And Thomas, of course, is very conservative. And then you have Alito, very conservative. Sotomayor, liberal. Kagan, liberal. Gorsuch, conservative. Kavanaugh, conservative. And Barrett, conservative. And interesting to note that 4 of them are from Harvard Law School, 4 of them are from Yale, and Barrett went to Notre Dame. They're all very bright people, smart as a whip, basically, and they work pretty hard. It's also interesting, I believe, to note that of the justices, 7 of them were brought up Catholic. They were, born into a Catholic family and brought up that way, varying degrees of, and one of those 7 is now Episcopalian, sort of practicing, and the others are practicing to varying degrees. You don't know, there's personal matters, that sort of thing. And the other 2 justices, 7 are brought up Catholic or raised Catholic, and 2 are Jewish. There are no Protestants or Episcopals or Presbyterians or Islamists or anybody else on the court. So it used to be they were all WASPs, white Anglo-Saxon Protestant men. 100 years ago, you probably wouldn't see it. Might be one Catholic, and maybe about that time they had one Jew, but that was a sort of one place for it, and that was it. Okay, now appointments to the Supreme Court. I just thought this would be worth talking about briefly, is because we just went through this terrible high-profile appointment of Barrett and Ginsburg. So I wanted to put that in a little bit of context, that lame duck appointments, and we didn't, are not unusual, and they were started from the very beginning. Chief Justice John Marshall, he's the greatest Supreme Court justice, in history. By all the judicial lawyers would say that. He was appointed by Adams. If you remember, Washington was the president for 2 terms. Adams was the president for 1 term, and then Jefferson mounted a fight. This was the first really factional fight for the presidency in 1800, and Jefferson won. And this was a dramatic change from the Federalist Party that Washington and Adams had to the, they called it Republican Party in those days. And Jefferson was a dramatic change in philosophy. Well, okay. In those days, the presidential inauguration occurred on March 3rd. The Constitution spelled it out, March 3rd. So the election occurred in November, and like 3 or 4 months, 5 months before the new president gets in. Well, during that interim period, Adams had lost the election. The Chief Justice of the Supreme Court stepped down. I don't know whether it was Jay or whatever, because he thought this job is not really, nothing's happening. It's not a very important job. So he stepped down. And so Adams appointed John Marshall, who was a big foe of Jefferson. And he was a very staunch very staunch Federalist. And so Adams appointed him, and Marshall was confirmed like in 2 weeks. It was and that wasn't considered like anything crazy or unusual. Of course, Jefferson was unhappy, furious about this development, but actually Adams appointed a bunch of judges after he had lost. And Marshall was the Supreme Court Chief Justice that he appointed. So that's happened before. It's happened a number of times. Scalia, we all remember the fight about that. And he died in January 2016. 2016 is an election year. And the Congress said, the Republicans in the Senate said, oh, well, we can't have a new justice. We have to wait till the election occurs. Well, that's kind of bullshit, but they had the political power to make it happen. And you knew that Obama was a lame duck in the sense that this was his second term. So he was at the end of his second term. And Obama nominated Merrick Garland. They wouldn't confirm him. And as soon as Trump got in, he nominated Gorsuch, and the Senate promptly confirmed him. And this was roundly criticized and attacked, and wailing and gnashing of teeth is a terrible thing. And well, a lot of times appointments to the Supreme Court had political stuff going on there. I mean, so we all think it's terrible, and it was terrible, but there's no new thing under the sun. This kind of stuff has happened in the past. Ginsburg is even more dire, sort of event. She died in September, and quick, zip, Trump appointed or nominated Barrett, and the Senate confirmed her, even before the election. So again, Trump was not a lame duck at the time. He might have won re-election. He was still fighting for that, as we all know. And so he wasn't a lame duck, but he did appoint someone just at the very end of his first term and just before the election. And that was considered outrageous. And you know, it was it was it was pretty hard knuckle politics. You know, that's known to have been known to happen on the court appointment process. Okay, now court packing. I just wanted to cover that briefly here. This is lame duck appointments, and then we got court packing, which would be, well, why don't we add some more justices to the Supreme Court so we can solve this problem. There's right now there's 6 conservatives and there's 3 liberals, and well, the Democrats are in power, so why don't we change? Why don't we add 5 liberal justices to the court, and increase the number of justices from 9 to 15 or 13 or whatever. Well, the Constitution doesn't say how many justices are going to be on the Supreme Court, so it's silent on that issue. The original Supreme Court had 6 justices on it because there were 6 judicial districts around the country, such as it was, 13 colonies. And each of the justices had to get on his horse and buggy or whatever and go out and work in these 6 districts. So there were 6 justices. And then they changed it to 5. And then they changed it when Jefferson was coming in, they reduced it to 5 because they didn't want Jefferson to appoint anybody. And then they changed it to 7, and then they changed it to 9, and then they changed it to 10. And they changed it. This is during the Civil War. They changed it from 9 to 10, and then they went back to 9 right after the Civil War, 1867 or something like that. And that was the last time it was changed. So 150 years ago. It's been 9 ever since then. Back in 1937, Franklin Delano Roosevelt tried to change the court, pack the court. He came up with this scheme which said, look, these justices, they're getting pretty old and they need help. They can't do the burden of all this work. And therefore, for every justice who's over 70 years old, we should add a new justice. So to help them with their burden. Well, that would have resulted in a court of 15 people in 1937. And Roosevelt had a clear, vast majority in the Senate and in the House, and he's president. So, and he could have probably gotten that through if he had, done it right. But he kind of popped it out on the Congress without any prior warning, and they were all upset, and it didn't go through. And so now they talked about, well, when Biden gets in, maybe he'll change the number of justices. Well, with a bare majority in the Senate, there's no way that's going to go through. So that's like a delusion at this point. Is not going to happen on Biden under these circumstances. Next, okay, how do you get a case to the Supreme Court? This is interesting. I think it's an important thing to know. Not every case gets there by far. So here's the basic procedural. This is the federal courts, the United States Supreme Court, the United States Courts of Appeals. There's 13 of them. The United States District Courts, 94 of them around the country. And so if you have a case and you go into the district court and you get convicted of a crime or whatever it is, a civil rights claim, and you're unhappy with it, you have a right to appeal to this Court of Appeals. And then you can try to get to the Supreme Court. I'll talk about that, but that's one route. The other is state courts. For example, the Chauvin decision. That was in a state court of Minnesota State Court. He was charged with and convicted of state crimes against state law. Second-degree murder, third-degree murder. State court, trial. Now, Mr. Chauvin, he doesn't like that. He has a right to appeal to the Minnesota Supreme Court. There might even be an intermediate level state court, but the states goes up to the state Supreme Court. And he may say, for example, my civil rights were violated. I didn't get due process because they failed to sequester the jury. And that jury was tainted by all the coverage and all this other stuff. And so they violated my constitutional civil rights, due process. Okay. Well, even though that's a federal constitutional argument, he's in a state court, so he has to raise that to within the state court structure, and the state Supreme Court of Minnesota would then rule. They might say, no, you got due process. You didn't violate the due process clause of the Constitution for you to the jury not being sequestered. Well, he might be unhappy with that decision, and so he would attempt to get it to the Supreme Court. So there's two routes to get to the Supreme Court. It's the main issue here. Now, when you actually want to get to the Supreme Court, the main point of this page is you don't have a right to appeal to the Supreme Court. Sometimes you hear people say, I'm going to take this to the Supreme Court, or I'm going to appeal to the Supreme Court. Well, you don't have a right to do that. All you can do is ask politely, please, Supreme Court, would you consider, please take this case, because I want you to review this case. And the request is called a petition for certiorari, or petition for cert. And so you have to file a request. And Supreme Court only will grant cert, accept the case for review if they conclude that the case involves very important issue of federal law, federal statutes, or an important issue of constitutional law or constitutional issue. So that's the criteria. Those are the criteria that are used for the court to decide whether to grant cert. And your chances are very low. Here's the average rate for the last year or two. 9,000 petitions for cert are filed in the Supreme Court every year, approximately. It's been going up. And average, they grant cert, they agree to hear about 80 cases. So your chances are less than 1 in 100, that the court will take your case. So it's a real long shot to get cert. And getting cert in itself requires you to file a brief saying this is an important issue of law. You should, it's crucial. You've got to look at it. It's so important. And then the other side files a brief and they say, oh, no, this is not a very important issue. You're too busy to take this case. You got more important things to do and worry about this silly thing. And so the court has to read these. The law clerks and the judges have to read these petitions and decide which ones they're going to take. 9,000 and then 80, they take about 70, 80, 90 cases. Okay, now let's assume for the moment that they have granted cert. You're one of these 80 cases that they said, yeah, we're gonna hear that case. And right now, the Supreme Court, last week, they're looking at these petitions, and every week or so, Friday, they'll say, on Monday, there'll be an announcement that we have decided to grant cert in this X case, whatever it is, and for next year. So next fall, the case will be briefed and we've seen. For example, just recently in the last week or two, the court granted cert on a gun rights case, Second Amendment case, coming out of New York. The case says the state of New York, in order to get a concealed carry permit in the state of New York, you need to file an application for a permit, And you have to show that you have a substantial need. You have what I've got it written down here somewhere because I wanted to get it right. Um, you have to show a proper cause of why you should get a concealed carry permit, and you have to show you have a special need for self protection. Maybe you're a police officer, or maybe you're a judge, or maybe you're being stalked by somebody, or you carry a lot of cash because of your job. A special need. And the New York State Rifle and Pistol Association or something filed a challenge to that, saying, well, wait a second, under the Second Amendment, we don't have to show a special need to for self-protection. We have a right to protect ourselves under the Second Amendment and carry firearms. And so you should eliminate this special need. And anybody who wants one can just file an application and get it. So that is the case. The Supreme Court says, okay, that's an important issue. That's a key issue. We're going to put that down for argument next year. We're going to decide that next year. And so that's coming up next year, Second Amendment case. Now, once you've granted cert, however, so next year, let's just say next year rolls around, on that case in particular, what are the mechanics? Well, the court will set up a schedule. There's a schedule, very strict, about the appellant. In this case, it's the New York State, Rifle and Pistol Association, because they lost down below. The Second Circuit said, no, you don't have a right like that. Or maybe it was the New York Supreme Court. I'm not sure which. They said, this Second Amendment doesn't give you a right to carry, whatever. So the Rifle Association lost. So they're the appellant. They're appealing, and so they're the appellant, and they have to file a brief. And it's a certain color. It's got to be printed on certain paper and certain margins and certain, type of a certain type of typeset, whatever. 5x7 briefs, and they stack up very neatly in your office. So then the appellant files a brief saying, this is why I should win, and there's a certain limit of pages and words and that sort of thing. And then the appellee, the person who's opposing, they file a brief. Then each party files reply briefs, and then amicus curiae, other people, will have a right to file a bunch of their own briefs. They may say, we're the Mothers Against Gun Violence, and we want to file a brief on this case. Because the case is actually just between the state of New York and this New York Gun Association. But other people want to jump in and, so they file an amicus, which is friend of the court briefs. And this is an appeal when it gets to the Supreme Court. Certainly it's an appeal, I call it, but it's not a trial. So you don't have witnesses, not like Chauvin trial. Some of you may have watched on TV. You got witnesses who talk about what they saw or what they did, or this sort of thing. No witnesses. That's all been done down there below. It's all written. It's all transcribed. It's in the written record, and the court can go look at all that it wants to. And then after they've got all this briefing and all these briefs here, different colors, piled up, they have an oral argument. They bring the lawyers in for both sides, and they say, okay, we want to talk with you about. We got some questions here. So here's the oral argument mechanics. The mechanics of it are that usually it's almost always it's 1 hour and 30 minutes per side, and you get a little red light, you get a green light, and it turns yellow, and then it turns red, and your 30 minutes is up, and they just cut you off in mid-sentence and thank you, goodbye. That's the end. And the purpose of the dang thing is not for you to give a 30-minute speech. Forget about it. You're not going to give a 30-minute speech. If you're lucky, you get a minute or two to talk about your case, and then they start peppering you with questions, left, right, and center, a lot of questions. And because the purpose of this, as far as the justices are concerned, is they read the briefs, they understand the briefs, and they say, well, wait a second, what about this scenario? Or I don't understand that. And so they ask questions and get clarification. Um, a couple of sort of interesting factoids about the oral argument. The justices all come out in their robes, at the same moment. They come from behind the curtains, the red curtains. But before they do that, they all go into the robing room. They have a room where they keep all their black robes. They go from their office to the robing room. They put their robes on, get their, tie straight or whatever, and they all shake hands. Every justice has to shake hands with every other justice. So each justice shakes hands 8 times, I guess it would be. And the mathematicians will tell us, a formula will tell you how many total handshakes that is. But they all shake hands because they want us, it's a tradition of civility and between members of the court. These oral arguments are open to the public, very strictly controlled in terms of cameras. You got to get there ahead of time and wait in line. And if it's a really important one, or big publicity case, abortion, gun control, whatever, boy, people get in line the day before. They stay all night, overnight. And there was a business those people would do. That's common in Washington, D.C., where a line holder, you could pay a line holder $40 an hour to stand in line for you, 12 hours ahead of time, or whatever you tell them to do. They show up and they wait, and then you take this piece in line just before they open the doors. Well, they don't allow that anymore. So that's verboten at the Supreme Court. It is allowed at Congress, and it happens in congressional hearings. And I think it's the best show in town in Washington, D.C. If you can get in to watch this oral argument at the Supreme Court, you're going to see real law in action being made, tough questions by smart people, tough answers by smart people. It's not a show. It's not a show like a lot of the congressional hearings are, where they have a hearing on some topic and the senators will ask questions, and the written statements are all there and they're reading a written statement. No, this is really lively and fascinating. I find it myself, and I've been to quite a few of them, and that sort of thing. Okay, so here's the oral argument. These are the seating again. Be prepared. You better be on your top of your game and know every nuance of your case. And here's after the oral argument. They listen to them on Monday, Tuesday, and Wednesday. And not always Wednesday. Sometimes they just have 1 or 2 days. And then on Friday, they get together in their conference room and they talk about the cases that they listened to that week. And they, kind of kick it around and try to figure out, what do you think? And it's interesting, the seating. The Chief Justice will sit here, and the all 9 justices around the table, and the least senior justice, which would be Barrett at this point. I'm not sure where she sits, but that person is kind of the doorkeeper. No one gets into this room while the Supreme Court is talking, not the law clerks, not the secretaries, not anything. And so if one of the justices needs something, or it's like, okay, hey, oh man, I need a pencil or something, the lowest rung the justice has to get up and go to the door and go out and say, hey, Justice Kagan needs a pencil, bring us a pencil. Or bring us a pizza. We always order a pizza, pepperoni, or no, they don't do that. But and so there's the lowest, the newest justice is the doorkeeper, and that's kind of a funny tradition they have. And they talk about the case, and maybe they'll do a tentative vote, and they'll say, oh, I think the gun rights case, I think the Second Amendment does not allow people to carry guns like they're asking. And they'll go around the table, with a tentative initial sort of read of what they think. And some of the justices may say, well, I'm not ready to sort of vote at this point. I need to go back and read a little more of the cases and double check something. And so they might not even have a tentative vote, but at some point they end up having a tentative vote. And they say, okay, it's 9-0, everybody agrees. Or it's, 6-3, or it's 5-4, okay. Now they've tentatively agreed. Let's say it's 7-2. 7 of them agree on the decision or what the outcome should be, and 2 of them don't. Well, the 7 of them that agree then have to figure out who's going to write this decision. The decisions are very important and are written very carefully. And to justices and to judges like I was, and lawyers like I was, it's not just the result of, up or down. A lot of the agonizing and the work, most of the work is done is, well, how did you reach that result? What was your reasoning? What did you think? So the rationale is very important. And they'll say, okay, who's gonna write this decision? They have to decide who's going to write the decision. So here's how they do that. The senior justice who is in the majority, let's say 7-2, let's say Roberts is dissenting, which is a very strange thing, but he's dissenting. So he's not in the majority. Well, and so Thomas, he's the senior justice in the majority. He gets to decide who's going to write the decision. He doesn't write the decision. He just gets to nominate. Why don't you write this one, Kavanaugh? You're not too busy this month, so why don't you do this one? Or maybe one justice will say, oh man, I really want to write this one. This is important to me, and so they'll do that. But oftentimes, if it's a really close case, it's a 5-4 case, sometimes it comes out and you say, well, that's very strange. Why did they have Kavanaugh write that decision or something? And one of the tactics that you use, you're the senior justice. You get to decide who's going to write it. It's 5-4, and one of the justices is wobbly. He or she is like, well, I'm not really sure, but I think I'm with you. So, I'm in the majority. It's 5-4, but I got some problems. I'm not really sure. So you say, okay, I'm going to give it to him to write or to her to write. That way, there's less chance he or she, that wobbly justice, will jump ship and go to the other side because he or she is writing the decision. So presumably they're going to be reasonably happy with writing it out. So less likely to have someone jump ship. I might add at this point, some people still have their video showing, if you could put a stop video as well as stop the audio, if you know how to do that, that would be great. So we're getting a few views of people. So any justice can write a dissent or a concurrence. And it's an iterative process. They all write the decision, the majority decision, the dissent decision. They share it with each other. They circulate it around to all the justices. They all read it. And maybe someone will change their mind and say, now that I think about it, I think the dissent is right. I'm going to switch sides. So it takes months sometimes to do this. And that's why they don't announce their decisions right there on the bench. When it happens, boom, here's our decision. No. It takes time and it's very carefully done in those briefs. You talk about obsessive compulsive, the people who write these decisions, the justices write them with their law clerks. And then they're reviewed by all the other justices and law clerks. If they get one comma out of place, it's a big, you lose face. So here we have 3 pernicious canards, and we're going to come here to a little bit to an opportunity for questions. So if you got any questions, again, chat, type something in. and we'll try to have a moment there where I can address questions with Ed's help. Canard number one. We all believe that, nowadays things are a lot worse than they used to be. In good old days, everything was fine. And now the last few years, the court has been more fractious and divided. And so this is a statistic that I showed from, it doesn't go right up to the present. I'm sorry about that, but it covers a long period of time. And it shows that the blue line is, the yellow line is the unanimous decisions during any given year, unanimous, 9-zip. And the blue line is the non-unanimous decisions. And they're obviously the reciprocal of each other, but it shows that generally there's a trend. It's not, we don't have a trend where there's more fractious. And in fact, it seems to be getting a little more unanimous. Blue is non-unanimous, yellow is unanimous. Canard number two is when they disagree, it's always a 5-4 split, or maybe now 6-3 split, and that's not true either. In the last 17 years time frame, we've got 46% or so of that were unanimous. And then these others are, let's see if I can move this. 8-1, the orange, 6-3, the green, or but tan, and so you see the 5-4s are pretty small, and then there's some 6-2s, 5-3s, 4-4s. There was a time period, for example, when Scalia had died, that they issued some decisions, so they didn't have 9. So that was one way to think about it. Another canard is they always vote liberal versus conservative, and that's not really true. That's not true either. This is one day in 2019, June 17th. All 4 of these decisions came down. June is a busy time. They issued a lot of decisions in June. And on that day, they broke out. And there's a lot of information here. Don't try to capture or understand all of it, but there was 4 different cases. One involved uranium mining in Virginia. One involved double jeopardy of a felon for carrying a firearm. Whether gerrymandering case involving standing, and a free speech case. Now, only in the free speech case down here at the bottom do you have the typical public relations media 5-4 split. The justices are shown here. This is the majority decision, this column here. The third column, or the penultimate column, this is the majority. This is a dissent. The majority includes, and the reds are the quote conservatives, and the blues are the quote liberals. And here we have 3 conservatives and 3 liberals, are all together. And likewise in the dissent, you had a mixture. Same thing with the other cases. There's a strange mixture of, well, an interesting mixture. These people are thinking hard and trying to do the right thing as they understand the law, and their alignment's all over the place. So there's not always 5-4, and they don't always liberal conservative, even on the court now. Okay, I mean, maybe this is an opportunity to think about questions. Do we have any? I don't know whether you're there, Ed, that can jump in or something. Do we have any questions?
At this point, there are no questions, Alex, but since we are at the 1-hour mark, it'd be a good time to take a 2 or 3 minute break. And also to remind people, as you mentioned before, in the bottom left-hand corner of your screen, you have icons for a microphone and a video camera. Make sure they both have 2 slashes.
Yeah.
We've had interruptions, but it's a good time for people to stretch.
Well, I'm going to go ahead. If people want to get up and take a break, a bathroom break or stretch, welcome to do it. I'm not going to be watching you, and I don't think anybody else will be. So hopefully, I want to get through this material, and I may be going a little too slow. I hope you'll bear with me. I will just go ahead and please take a break if you want to, go get a cup of coffee or, whatever. But I'm going to go ahead if I may. But please, if you've got questions, please put them down in the chat. Okay. Basic principles of Supreme Court and generally law in general. Precedent. We always hear about precedent, and I'm just going to pull all these up at the same time. Precedent is when the Supreme Court decides an issue, the decision is binding and must be followed by all lower courts, federal courts, state courts, the government, the Congress. Everybody's got to follow. Once they've decided that issue, it's the end of the debate, as it were, and everybody's got to follow it. So if another case comes down the pike, 2 or 3 or 20 years later, that seems similar, one side will say, well, look, this is the same issue that they decided in 1980, and there's no big issue here. So there's precedent, it's binding. The lower courts can't change anything. And the other side will say, oh, no, this is a different issue. This is slightly different. So it hasn't been decided, and it is important, and we need to, we're not bound by that Supreme Court decision in 1980. So precedent. And the other thing is to know that precedents, prior decisions by the Supreme Court, do not bind the Supreme Court. They can always change their mind. So this is where the concept of stare decisis comes in. Stare decisis is a doctrine, not a constitutional legal principle. It means, it's Latin, of course, to stand by the thing decided. And the Supreme Court has this approach. It says, look, if we've already decided an issue, and again, you can debate about whether it's the same issue or not, but once we've decided an issue, we're not going to look at it again. There's no reason for us to repeat ourselves. So we're just going to follow our own decision. And everybody else obviously has to follow it too. That's precedent. But the Supreme Court doesn't have to follow its own decisions. So when someone says to a Supreme Court nominee, and one senator asks the nominee, well, do you think do you believe in precedent? Yes, I do. And do you agree that Roe versus Wade is binding precedent? Yes, I do. Okay, but that doesn't mean that this justice won't reverse that decision, because the Supreme Court is not bound by precedent. The Supreme Court can change its mind. And why do they have this stare decisis doctrine? This is where they say, as a general rule, we're not going to go back and review Roe versus Wade because we've decided it and we don't want to do it again. Partially, it's judicial efficiency. Why should we decide the same thing over and over again? And the other is predictability and public confidence. Public confidence in the Supreme Court would be undermined if they kept changing their mind all the time. But the Supreme Court can reverse itself and does. So reversals, famous reversals. The court is not infallible. It makes mistakes, changes its mind. Segregation, equal rights under the 14th Amendment. Plessy versus, the most famous we'll all remember, Plessy versus Ferguson said that, separate cars on a train for black people and white people is fine, separate but equal. The equal protection under law doesn't require them to be combined. Separate but equal is fine. Brown versus Board of Education, this is in the context of education now, said no, separate but equal just doesn't cut it. First off, there's another question of whether it really was equal, which it wasn't, of course. But so they could have decided it on that way. The court in Brown could have said, well, yeah, separate but equal is right, but this was not equal. So go back and fill and look at it, or whatever, rule in favor of the black children. But they didn't do that. They said, no, separate but equal is inherently unconstitutional. And so even if it was totally equal, it's unconstitutional to separate the races that way. Another one is free exercise of religion. This is I put this one up just to show how quickly, 1940, the decision, 1943. This is where Jehovah's Witnesses refused to salute the flag of the United States in school. And they believed that this was a derogation of their religious rights, and they cited the Nazis in Germany who were making children salute the Nazi flag. And the Supreme Court held, well, that's baloney. There's nothing wrong. Everyone should have to, all school children should salute the flag. Does not violate your First Amendment right to religion. Well, they thought about it, and pretty quickly thereafter, they reversed themselves. The same issue came up, and it's like, well, this is the same issue, isn't it? But they took the case and they reversed it, saying, well, now that we think about it a little more, you don't, if you have a religious belief, that you don't have to salute the flag. And of course, there was rioting. I mean, the people in Pennsylvania and West Virginia, these not Seventh-day Adventists, Jehovah's Witnesses took a lot of flack. I mean, there were people being beaten up in the streets, and maybe I think there was one murder in there. Another one is the New Deal, which is FDR trying to get us out of this depression, passed a lot of legislation, and the court kept ruling it was illegal or unconstitutional, violation of due process and other things. And the Supreme Court reversed that pretty quickly. Recent reversals, gay rights, for example, reasonably recent. In '86, the Supreme Court ruled that, Texas law making homosexual sodomy a felony was not unconstitutional. So the Texas law was fine. Obergefell was decided, and it said states cannot prohibit gay or lesbian couples from getting married. Now, it's not the exact same issue as you see. It's not, but it's a clear reversal. Likewise, internet sales tax. This one hits all of us in our pocketbook. As whether or not if a business that's located entirely in New York sells cameras, equipment, or something, I'm sitting here in California and I order a Nikon from them, and they ship it to me. Hey, it's great. It's good camera, a good price, whatever. Up in the old days, under 1992, the Supreme Court said California's sales tax does not apply to that kind of transaction because the seller has no presence in California. It doesn't have a business in California, doesn't have a camera shop, doesn't have any people. And in 2018, the Supreme Court reversed that and said, yes, you can impose sales taxes. California can impose sales taxes on stuff sold from New York. And big deal. So we all lost that opportunity to save taxes by buying something from out of state. Okay, again, we're about to get into the developments and decisions currently pending. So I'll ask again, do we have any questions?
We do have some questions for you. Lori and John Schneeman want to know, when a Chief Justice leaves, how do they choose who is the next chief?
Okay, good question, good question. The justices, that's not up to the justices. It's up to the president. If the Chief Justice retires or dies, then the office is vacant and the president gets to nominate whomever he or she wants to nominate, and the Senate, of course, has to confirm that person. So, for example, when the Chief Justice died in 1953 of the Supreme Court, Eisenhower nominated Earl Warren, for example. It's not like the next person in line goes up, or the most senior person goes up, or the justices sit down and say, okay, who should be the chief? No, it's just up to the president and the Senate.
Dick Jackson has a question. Please comment on the originalist theory. Who follows these days? Who does not?
Major good question from Dick. I would say it's more of a textualist. You know, we often refer to it as originalism, but Scalia was the primary proponent of textualism, which is to not. Some people say, well, what Scalia would say, what do the words say? Let's read the Constitution. Let's read the words of the statute, the Civil Rights Act of 1964 or the Antitrust Statute. Read the words of what is said and get a dictionary out and say, okay, what do these words mean? And you probably want to get a dictionary out that was current dictionary when those words were written, whether it's 1789 or 19 or 2003. Get the dictionary that was operative at that time, or dictionaries. I mean, it's not really that literalist, and say what was the meaning of that word in those days of a common parlance in the dictionary. You don't ask, in fact, you specifically avoid saying, well, what did they intend? The other side of the coin is, well, yeah, I know the words. For example, last year, there was an issue of whether under the Civil Rights Act of 1964, when the Congress wrote in 1964 that prohibited discrimination on the basis of sex, the question was, well, does that include transgender and gay discrimination, gender discrimination? And the justices all agreed that nobody in Congress in 1964 ever thought that discrimination on the basis of sex meant transgender or gay or lesbian. I mean, if you had asked them that, they would have just been horrified at the prospect. No, that's not what we mean at all. So it was not their intent. So the question then became, well, yeah, forget about their intent. There's no way you can figure out what everybody's intent was. How do you get inside their heads? The Senate's head, how? So instead of that, you say, well, let's just look what the words said and what the words meant back in 1964. And, is this covered or not? Okay, now that's the background. Now the question is, most of the court nowadays has moved towards the textualist's position. And it's kind of original text, the text of the words as written in those when it was written, and there's much less. I mean, the conservatives are much more of onto the textualist interpretation. The liberals, Breyer, more say, look, the Constitution is a living document. We've got to have it. You have some flexibility to be able to deal with modern situations. And even though the words are not clear, or maybe they didn't, we need to be able to have some flexibility. So I'd say the liberals, the conservatives are all textualists, originalists, really, but they don't go to original intent. Don't use that word. It's not intent.
Joan Rice has a question. If Supreme Court decisions on concealed weapons case passes, will it apply to other states, or is it just a precedent?
Oh, good point. Well, it will apply to other states, so that once the decision is rendered on that, saying the Second Amendment of the Constitution gives everyone a right to carry a gun wherever they want all the time. Let's just say they said that. God forbid, but then that would apply throughout the country. And if somebody in some other state decided, well, I don't care about that, the state of California said, well, screw that, we're still going to regulate this stuff. Then anybody in California could go into court and say, here's a binding precedent, California, you got to crack the whip, get in line. The Supreme Court's ruled on this, and everyone's got to comply.
Ron Workman has a question. Is this judicial branch truly separate if judges are nominated by the executive branch, confirmed by the legislative branch, and the legislative branch determines the structure of Scotus? For example, they determine how many judges make up Scotus.
Mm-hmm. Well, I mean, yes, it's a good point. They founders, whatever, were trying to write the Constitution, trying to figure out how are we going to do this. And so there is the nomination and the confirmation of the justices, the number of justices, the budget for the Supreme Court. Sure, are they they don't have their own power to tax, they don't have their own power to enforce. In some senses, they were always thought to be the weakest branch of the government. But yeah, I mean, but they are, once you get appointed to the Supreme Court or any justice or judge at any level, pretty much, some states have elections, but when I was appointed, you're appointed, you're in there for life. And you can't be impeached. I mean, you can't be fired. You can only if you get impeached, high crimes and misdemeanors, and convicted. So, I mean, you've got people's power over you is you're pretty autonomous, totally independent, perhaps not in that respect. I can see what he's saying.
Lori and John have another question for you. If common knowledge is contrary to the Constitution, does the court ever comment to clarify? For example, separation of church and state in France, but non-establishment of religion.
I'm not sure I understand the question. Could you repeat it or whatever?
Well, I'll read it as written. If common knowledge is contrary to the Constitution, does the court ever comment to clarify? For example, in another course I learned, we don't have separation of church and state like France, but non-establishment of religion.
Good point. I mean, there's a couple of points there. Yeah, I mean, the First Amendment doesn't use the phrase separation of church and state. It simply says Congress shall make no law establishing a religion, and nor shall people's rights, and I don't have the exact word, to exercise their religion. So you have free right to free exercise of religion, of your own religion, and Congress is prohibited from writing any law that would establish a religion, that would build, have a state church or a federal church that everybody has to pay taxes to. Note, if you will, that in 1789, a number of states did have state religions. In New England, they had perhaps it was the Calvinists or the Congregation. In Virginia, whatever. Some states had their state religions, and taxes were paid to the state church.
Okay, someone has put forth a good suggestion in that people are eager to hear the most recent court cases.
Okay, maybe we better jump to that. Let me we'll try to get to these other questions when we get towards the end. Okay, let me jump to that. I have a few more slides here. Okay, I wanted to just reflect this, and this slide has a lot of stuff in it. Please don't get bogged down in it, but this is the first reversal that the Supreme Court has done since Barrett showed up. And so, and it dealt with COVID. States are imposing COVID restrictions on indoor activities. And then these all deal with the state of California, because it just happened that they decided to do the California cases. They're all a church against Newsom, Governor Newsom, 3 cases. And before Barrett, BB, or maybe we could call it, in last year, the court ruled that the question was, well, there's some restrictions on the exercise of, you can't have indoor church services. And they're saying, well, we have a First Amendment right to exercise our religion. And this is an outrage, for you to restrict that. And the Supreme Court ruled last year, May, no, it's not a violation of your free exercise of religion. We're going to defer to the state. State makes rules trying to deal with a health pandemic emergency. And this doesn't seem to be a burden on your free exercise of religion. Next time they said the same thing came up, essentially the same thing, and the court reversed and said, yes, it is an undue burden on your right to exercise your free religion, and therefore the California COVID restrictions on churches, worship services, is unconstitutional. And you see the reds or the changes. Roberts was in the majority and Ginsburg was in the majority. Now, Robert Ginsburg is gone, of course, and there's then there's Barrett, and Roberts changes his mind. They did a reversal, and Roberts changes him. Roberts likes to be in the majority if he can help it. And then they did another decision about home worship. This more recently, just the last month, dealt with worship, groups of people getting together at home. And again, it was a reversal, direct reversal of the court within several months as a result of Barrett. Here's the Presidential Commission on Scotus. You may have heard about this. April 9th, Biden issues an order. It's saying, well, I'm going to set up a commission, a blue ribbon commission of distinguished constitutional scholars, and they're going to issue a report within 180 days about the court, the nomination process, the confirmation process, the number of justices, the petition for certiorari process, anything you want to talk about, here's a report. And Biden promised he would do this. He was kind of, during the campaign, he was asked about, enlarging the number of people on the court. He kind of evaded that question. He said, well, I don't know. I'm going to appoint a commission to look into it. So he's done that. And you got 36 distinguished, and these people really are good. I looked at the list, all the major law schools, blah, blah, blah. But the odds of them coming up with anything that is more than sort of platitudinous is going to be pretty tough, because it's hard to get, any 2 or 3 lawyers to agree on anything, much less 36 distinguished constitutional lawyers, scholars. So it's maybe the mouse that roared. I'm not sure. It'll get some publicity and be interesting. Next issue, will Breyer step down? Major decision. Ginsburg was urged to step down when there was a Democrat in office, Obama, because her health was dicey. And she said, no, I'm going to hang in here. I love it. I'm doing a great job. Everybody loves me. And boy, I can do some good things. And Hillary's going to win anyway. So I'll just hang in here. Well, that didn't happen. And she died. So Breyer is he's the liberal justice. And Democrats have got a 50-50, as it were, majority. And so there's a lot of people commenting right now, Supreme Court watchers and scholars, urging him to step down. He's 83. He's not sick, as far as anybody knows, and he's doing a good job. He may say, well, hell, I like this. I'm doing great. But all you need is one Democratic senator to drop dead of a heart attack, and that Democrats may lose that thin margin. In 2022, who knows what's going to happen then. So people speculate that he may step down, say June 30th or July 1st of this year, because that's usually when they do it. And Biden promised to appoint a black woman to the Supreme Court. Here are the short list. Here's a short list I put together. And this woman right here, Ketanji Jackson, she's high profile. She's the one I think will be appointed if and when Breyer steps down. She's very smart. All these people are smart. And she clerked for Justice Breyer. So he knows her. She knows him. He likes her. And you got to convince him. You got to go to Breyer and say, Stephen, let's make a deal here. You step down and we're going to appoint your former law clerk who you know and like, and we'll put her in there so that your legacy will be preserved. So that could happen. So here's those decisions. First one involves free speech. I call this the case of the cursing cheerleader. And you may have seen some publicity about this, news about this this week, last week. Uh, it the precedent of this case back in 1969, when I was in the Supreme College, the Supreme Court in Iowa. I was in college in Iowa. Supreme Court ruled in Bonnie Tinker versus Des Moines Public School Districts that students have a right to wear black armbands in school to protest the Vietnam War. And the school would kick these kids out, Bonnie Tinker and her sisters and a couple other people, for wearing black armbands. And the court said, no, 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 wait a second. People have a right to free speech. And just because you walk into a public school doesn't mean you lose your right to free speech. But schools do have authority to regulate speech that would materially and substantially disrupt the school. Okay. And wearing a black armband didn't disrupt anything. So, they held in favor of Bonnie Tinker. Well, Bonnie Tinker went to college with me in Iowa, Grinnell College. So I knew her, interestingly enough. And she was like, oh, yeah, you won the case. And it was kind of funny. And now there's a new case of a 14-year-old girl who was on the JV cheerleading team, and she applied to tried out for the varsity cheerleading team, and she didn't make it. She got cut or whatever, and she was still on the JV team. And she went back to her house. She didn't wear a black armband in school. She didn't do anything in school. She went back to a coffee shop actually and took a Snapchat with her cell phone, and she said, F the school, F cheerleading, F the coach, whatever, cursing about. And she had her middle finger showing on her picture. And about 250 of her friends, some of them schoolmates, saw this. And one of them printed it out or something and saved it and showed it to the coach of the cheerleading. And the coach cut her or suspended her from the cheerleading. So the question is, under Tinker, and did that violate her right to free speech under Tinker? And there's sort of two questions. The lower court, the Third Circuit, said, well, since it didn't happen at school, it's automatically okay. They made a strict sort of geographical, if you're in school, then they can regulate it. If you're out of school, no, you can't regulate it at all. And there was an appeal. They had the argument last week. I listened to the argument, all the justices and lawyers. And they said, well, just because it's automatically off campus doesn't mean it couldn't impact the campus. What if a kid reads her Snapchat while she's at school? Was that at, so the geographic limit, and also did it materially and substantially disrupt? Did it have a tendency to disrupt the school? So the court is going to address that. It's the first public, speech issue in 50 years, and it'll be a headline one. Next is another First Amendment case, free speech versus donors list, secret donors list. You might call it secret donors or confidential donors. This involves California. Over here is the name of the case. I'm sorry, I go back here. I want to go back to the prior page. The name of that case is Mahanoy Area School District versus BL, Brenda Levy. This one's American for Prosperity, and there's two cases. And the issue here is California drafted a law recently. Actually, the Attorney General issued regulations saying all registered charities in the state of California must give us the names of their major donors. Give us a list of their names of their major donors. And these two conservative groups challenged that. One of them is by the Koch brothers. I believe it's this one here. And the other is a conservative anti-abortion law firm, law center. And Becerra is the Attorney General of California now. So the question is, well, California wants to know the names of these charities. And does it violate the First Amendment right to assembly and to free speech of the donors? They don't want their names revealed. Well, back in 1958, the court had dealt with this in NAACP, where the state of Alabama wanted the names of all the donors and members of the local chapter of the NAACP. And they said, the people said, no, we don't want you to give our names. You're going to harass us. You're going to fire us from our jobs. All sorts of bad things happen. So the court upheld the right of the NAACP not to give the names of its donors and members, major donors and members. So interesting problem. Shoe is on the other foot. And I suspect California was going to lose this one. But anyway. Another First Amendment case, free exercise of religion. This one involves foster child programs in Philadelphia. City of Philadelphia had a foster child program. They outsourced some of that work to various NGOs. One of them was the Catholic Social Services. They help place foster children in foster care. They're actually pretty good at it. And LGBTQ lifestyle contradicts the Catholic religion, their interpretation of the Catholic religion, or whatever, And so they said, well, we'll place kids in foster care, but we can't do it to put them into LGBTQ homes. And Philadelphia, and they've been doing this for years. And so, but Philadelphia came up with a new policy, and because the Supreme Court had already ruled that cities and states cannot prevent people can't not place people in foster care due to being a gay family. It already ruled that. So they kind of got close to the issue, but this one was more of terminating the Catholic services from serving. So they could say, well, we'll use Catholic services for Catholics and we'll use somebody else for the lesbian and gay community, and we'll be okay. Well, so does banning a Catholic charity from a foster care program violate the Catholic charities' religious belief, right to a First Amendment free exercise of religion? And that'll be a case, and the odds are reasonably good from the commentators that the Catholic Church will win this one, that it does violate their free exercise of religion by terminating them so that may be a 6-3 decision right there. Community caretaking. Okay, the situation in the community caretaking is, all right, let's say I have a elderly neighbor who I see every day out in her garden. She's frail. Her health is very frail. And I say hello to Jane every morning or and suddenly I don't see her. She doesn't have any friends or family. She lives alone. I don't see her out there. I'm worried about her. So I call the police up and I say, hey, Jane Doe, she lives next door. I haven't seen her outside in 3 or 4 days. Could you send somebody over there to check on her? And they say, okay. So they send a cop over. And he knocks on the door. Nobody answers. And, well, the door is ajar, or he goes around the back and he looks, and somehow he gets in the house. The door is open. He gets in. He looks around, and she's laying on the floor with a heart attack. Or let's say she's not laying on the floor with a heart attack, but you just had the police enter a home and search the home for the person without a warrant. Is that unconstitutional? And so in this case, the facts are kind of bizarre, but there was a marital dispute. Husband and wife were fighting. The man at some point finds a gun in his bedroom or something. He's got a handgun. He pulls it out and he puts it on the kitchen table. And he says, look, this is terrible. Why don't you just shoot me? Here's the gun. Shoot me, put me out of my misery. I don't know, something like that. And she calls the cops. The cops show up. They take the man away. They do a psychiatric evaluation on the man, and the psychiatrist says, this guy's fine. He's not crazy. Everybody's calmed down. So no problemo. Go home. Then, but that same day, the day after the dispute, the cops, while he's down there with the psychiatrist being evaluated, they go into the house and they search the home, and they seize the gun and the ammo. Now, they don't have a warrant, but they felt that given the community caretaking, this person is in a distressed situation. He's not, we're worried about him and his wife, so they go in, they take the gun and the ammo. Okay. Does that violate the search warrant? The Fourth Amendment says you can't go into somebody's home without a search warrant. In a non-emergency situation, can the police enter a home to check on the residents' welfare without getting a search warrant? It's a very interesting question, I think, and we'll get a decision in the next, 6 weeks or 7 weeks. I've just got one or two more, and then we'll have some more questions. Hopefully I can get back to some of the questions. But I think we're about 10:35, and this thing's set up to go to noon if need be. So there you go. Fifth Amendment case. This is another California case. California seems to have a penchant for, pushing the envelope, shall we say. Okay, farm workers union. You all remember when we boycotted grapes for many years and all sorts of things. The farm workers now have the right to unionize. But here's the problem. The farm workers don't go to work in a factory. They don't have meetings. They don't, accessing the farm workers is harder. So California passed a law that said, look, union organizers who want to talk with the farm workers and try to organize a union, well, the landowners, the people who own the ranch or the farm, wherever the crops are being harvested or the farm workers are working, the landowners have got to allow the union organizers to enter their property, and that's to try to organize. And there's a time frame. It's for 3 hours a day for a 30-day period, 4 times a year. So 4 months out of the year, they got to give the union organizers 3 hours a day to come. And they can't interrupt people who are doing their work. You can't go out in the field and say, hey, stop picking those, watermelons or something and come and talk with me. It's got to be during breaks and other times. But so it seems like, well, that's not that unreasonable. But the landowners say, wait a second, that's an easement. We own this land. I own this land. I don't have to let anybody onto my land unless I want to. And, if you force me to let Joe Blow come onto my land, 33 hours a day, it's an easement. You're giving someone a right to my land, to access my land. So the issue is the Fifth Amendment says there shall be no taking of private property without just compensation. And granting an easement to somebody to get onto your property is a taking of private property. So there's not a whole bill of question that it's a taking of private property. And there's no compensation, it's not being paid. They're not, the California law doesn't say, and the union organizers pay them $10 a day for the privilege. So does it violate the Fifth Amendment? And that'll be an interesting one. I don't know how that'll turn out. Cedar Point Nursery versus Hasid. Close to final case. Student athletes. This is one you may have heard about, which is the National Collegiate Athletic Association prohibits student athletes from being paid. And football players and basketball players, college, challenge that rule. It wasn't any. Those are the two: men football players and basketball players. I don't even know whether women's basketball was included. Yeah, I think women's basketball was included. Obviously, there's no women's football. And does that rule violate the antitrust law? I mean, because what you've got is a bunch of competitors, colleges, who are competitors, who are restricting, have all gotten together and they said, we're not going to pay these athletes, and we're not going to let our athletes be paid. Well, a bunch of competitors just made an agreement. Does that violate the antitrust laws that prohibit competitors from getting together and fix prices or fix terms of employment or whatever? And finally, I think this is my last one, alien tort statute. This is a little weirder. It's not, there's a lot of material here, but it involves child slavery on chocolate plantations or cocoa plantations in Africa. And the alien tort statute is something that's, you know, foreign governments, foreign people. So the statute way back in 1789, I guess when the Constitution allows foreigners to bring a lawsuit in the United States court for serious violations of international law. It's not been used very much, but you know, it's kind of like, well, if something happens over there in Africa, how in the hell should the United States courts have jurisdiction to decide whether what they happened in Africa is is legal or not? I mean, go to the African courts. You know, what we can't issue decisions on every country in the world, what's legal or illegal over there. So, but there are certain circumstances where we foreigners can sue for serious violation of international law. So the facts were 6 children sold into slavery to work on plantations. They were tortured, they were abused, they were slaves. U.S. companies, Nestle, Cargill, they bought cocoa from these plantations. They didn't have they didn't have anything to do with the slavery. They just bought cocoa from everybody. They bought it from these plantations. The allegation being made by the plaintiffs, these 6 children are now grown a little bit, that the corporations aided and abetted in and this is, you know, statute says it has to be a serious violation of international law. And everybody agrees slavery is a serious violation of international law. So the issue is, can these companies be liable under the alien tort statute and international human rights law? Well, I think the answer to the international human rights law is ain't going to happen. That doesn't govern the United States. There's no U.S. statute on international human rights, but it might be a tort. You know, the question is did they aid and abet? So the question is, did any part of this involve anything that happened in the United States? If everything involved occurred outside of the United States, what is our connection? What is our country's role, right, responsibility vis-a-vis activities that occurred totally overseas? Now, they bought the cocoa, and that's all they did. And maybe that's enough. The court is going to have to rule on that. Okay, now I appreciate your patience. You've been with me this whole time. Lots of stuff I covered. I hope it wasn't too much. There's 2 great websites here on the Supreme Court. You get a lot of information on the governmental one, but this is really the best. Scotus blog. It's a lot of lawyers who are specialists in the Supreme Court. These are smart people, and they've been involved. They know the court, so it's not just a bunch of yahoos, you know, writing emails about what they think. This is very knowledgeable, and it'll give you a huge amount of information. And I have it tabbed on my computer. So with that, maybe a few questions if we want to do that. Ed, anything on the chat room?
Here's a classic Dick Jackson question. Wouldn't consistent textualism limit current firearms possession to flintlock muzzle loaders?
No, not necessarily. The Second Amendment, I mean, deals with right to bear arms. Okay, what are arms? They aren't necessarily limited to pistols or muskets or, you know, firearms like we think of. It could be a sword or a knife or a mace. They use the word right to bear arms, and so yeah, but it wouldn't be to say, well, uh, I guess a musket or a flintlock. Flintlock would be an example of a firearm or an arm that existed in 1789. But I'm not sure that would be the definition of what what an arm is. Arms are, weapons that could be carried by an individual or whatever. So I think the definition would be a more conceptual definition, even then. And then the actual examples that existed then would be limited. Of course, they wouldn't have, machine guns and all this other stuff, but the definition that existed then as a weapon that could be used to harm or kill other people or whatever certainly would be a proper 1789 definition, which would then encompass modern weapons or modern arms.
Ron Workman has a question referring to your last case. If Nestle and Cargill are guilty of aiding and abetting, what does that say about all of us people that ate the chocolate bars?
Exactly. There's a slippery slope sort of problem here. And keep in mind, this is not a criminal statute, so guilt was not necessarily the right word there. Liable as a tort for damages. But, there used to be a guy named Tom Newhouse. Many of you may have known him. He's a great friend, and he operated Mama Ganache chocolates here in town. And he later, a couple of years ago, he sold it and moved to France. But he has a great foundation, charity involved. And he talked about the horrible conditions in Africa for people trying to raise cocoa beans and not getting any of the profits. And it's one of these things where he's trying to help them out. But okay, you eat chocolate bars. Are you complicit in the slavery of these children? Yeah, slippery slope.
Hal says he doesn't have a specific question, but he would enjoy hearing your thoughts on 1, Citizens United, and 2, the Federalist Society.
I think Citizens United was a very unfortunate decision and unnecessary. I disagree with it, and I think I don't think that corporations necessarily should enjoy that kind of right, and I think that was a wrong decision. I mean, I won't get into the details. The other one about the Federalist Society, I think the Federalist Society I'm not a member of it or anything like that, but it's a legitimate and important group of scholars and people who have a conservative philosophy vis-a-vis the interpretation of the Constitution and the federal government. There are other organizations. There's the American Constitutional Society, I think it's called, which is a liberal group that was formed, 15 or 20 years ago, that is attempting to do the more contextual, liberal interpretation. Society of justices and lawyers, and judges, lawyers, scholars, students who believe in a more liberal interpretation of the Constitution. And I've attended some programs that both of those, not in person, but like online or something, that both of those groups put. Nothing wrong with it. Federal Society it's very powerful. The conservatives rely on it very heavily to create a pipeline of conservative judges and people who would be appointed to, work for the president and that sort of thing. So yeah, very
Nancy
powerful.
Wells has a question for you. She says, regarding proposed reforms for the Supreme Court of the United States, is this politics or are there some worth considering?
Well, I think it's a bit of both. I think there are some reforms worth considering, and it is politics substantially. What could be done? One, I think, a very interesting idea was reforming the Supreme Court, and this would take a constitutional amendment, which is almost impossible to happen, but to establish there's 9 justices on the Supreme Court, and to establish term limits for each of the justices of 18 years. So when you get appointed to the Supreme Court, you've got a term of 18 years and then you're off. No reappointments or anything like that. And set it up in a sort of staggered system so that every 2 years, one of the justices' term would expire. And so each president would presumably, each 4 years, you'd get a chance to nominate 2 people to the Supreme Court. And I think that would work. I think it would be great if you could do that. But yeah, but it is politics. I mean, getting it through, getting a constitutional amendment through, it's just forget it. Statutory things like changing the number of justices, politically easier because all you need is an act of Congress and the president to sign it. But right now, I don't think I don't think we're going to get very much at all right now in this environment.
Canberra Baronick wants to know your thoughts regarding taking of property by prohibiting collecting rent during pandemic or just rent control.
Well, that's a good question. I mean, I think there is a problem there of the government sort of just announcing, well, you're a landlord. Let's say I have a house in San Luis Obispo, and I decide to move and I want to rent my house out to a nice family or some students or whatever. And okay, I'm renting it out, and all of a sudden the government pronounces that those kids, those college students, they get to stay there for free. I can't collect any rent, and I'm paying the mortgage on my house. I still got to pay the mortgage, or maybe I get some relief on the mortgage, maybe I don't. But you just say the government edict. They just took my property away and gave it to these kids to stay there indefinitely or until the COVID is over with. I think there is a takings problem there. Government may solve the problem by saying, okay, landlords, we're going to give you a break on your mortgages or something. And so we are giving you compensation. There's some sort of quid pro quo going on. But yeah, I think there are circumstances where I think there will be takings cases raised after this COVID thing subsides.
I believe that wraps up our questions. So on behalf of the Board of Lifelong Learners, I would like to thank you, Alex, for your always valuable contributions. I would also encourage anyone else out there who is interested in presenting a lesson to apply via our website. I will echo Alex's sentiments. We are trying to present live presentations in the fourth quarter. So Alex, any last comments?
Well, just want to say thank you for everyone bearing with me and hanging in through this presentation. I have a lot of good questions. I'm glad we had a little bit of time for some questions. And I hope you will keep an eye out and watch the Supreme Court as these decisions come down. And you may, as Marcia Coyle and the Public Television News Hour will probably comment on the case of the cursing cheerleader or some of these other ones. Hopefully you will know a little bit about that case and be able to say, yeah, I remember that one. And if you ever want to study the issues, you can get on these blog sites, the Scotus blog, and you learn a whole lot more. So thank you all very much for listening, and I appreciate it. I enjoyed doing this, as you probably could tell. So it was fun. Thank you. All right, I guess we'll sign off now.